sea change, a fundamental sea change of Tennessee jurisprudence is just nowhere to be found in Kaufman. My friends in the Court of Appeals assert that this anomalous change must follow from Kaufman's admonition that, quote, manufacturers have no duty to warn with respect to products manufactured and sold by others. But Woodruff has never alleged these defendants were obligated to warn about something uniquely defective about the other's product. She's never alleged this. And the notion that manufacturers have no duty to warn on another manufacturer's product, just like in the DeVries case, as Justice Kavanaugh calls it, it's black letter law. But what it really means to say is that we're not going to make one manufacturer the insurer of another manufacturer's product. And we do that if we make a manufacturer the insurer of, or if we give that manufacturer a duty to warn about a defective other product.
Mr. Collins, what do you see as the key distinction between this case and the Kaufman case? I mean, the Kaufman case also, involved, at least arguably, the combination of two products. So what makes this case different, such that we can retain Kaufman but reach a different decision in this case?
I think the first point of contrast is that this case involves on-product warnings, or in the case of Derell, an instruction manual accompanying the product. Woodruff claims the inadequacy of these warnings and instructions that accompanied the product are what render it unreasonably dangerous under the Tennessee Products Liability Act. Now, there were no warnings whatsoever in Kaufman. What this court was tasked with in Kaufman was determining whether the equipment manufacturers would be held to an abstract duty to warn, what you might call a standalone duty to warn, of this later integrated asbestos-laden product. And the court said no, because the equipment defendants did not make the dangerously integrated end product that actually harmed Mr. Kaufman. Here, though, Ford certainly made the seatbelt extender that harmed Ethan Woodruff, and Derell certainly made the booster seat that harmed Ethan Woodruff. And so
I guess I can see your argument with respect to the seatbelt extender itself, but I mean, how is the booster seat distinguishable? I mean, how did the booster seat itself, injure the victim in this case?
Yes. If I understand your question, Justice Campbell, we know that seatbelt extenders are never appropriate for use by a child. They just simply aren't. The geometry is way out of whack. And of course, we know that Derell instructed users to go see about an extender, which Woodruff claims is an endorsement. Question of fact, the jury can decide on that. But how did of course we say that the only reason the extender was used at all was because of Derell's endorsement. So there's that. But more so, when in a collision, when a child is using a seatbelt extender, booster seat or not, the geometry is thrown off, the weaker parts are put in the wrong place, and the child can be released. But when you introduce a booster seat, that risk goes up substantially. And in this case, if we went into the gory details,
because of how it's positioning, because of how that's positioned.
And not only the positioning, but also the hard parts of the booster seat itself. So now, instead of the soft tissue and the child, we have these hard plastic parts, further applying pressure to the weaker metal latch plate and buckle.
So it's not just that he happened to be sitting in a booster seat when it happened, it was that the booster seat itself helped contribute to...
Yes, Your Honor.
Okay.
Yes.
So is there a difference? Kaufman was essentially a statutory interpretation. Is there a difference at all in that sense in this case? Is different language at issue? How does the fact that Kaufman was a statutory interpretation case, does that make any difference as to why it's not applicable here?
Yes, in this sense, if I understand the question. Kaufman turned so heavily on Section 105A and the language that we judge from, we judge a manufacturer's, whether a product is defective or unreasonably dangerous at the time it leaves the manufacturer's control. Of course, this has been a sine qua non of products liability all the way back to the restatement. Like it's always been that. But here, again, what mattered in Kaufman is that they didn't make the offending product. But here, the defendants did make the offending product, and they distributed the offending product. And so I think that is, that just wasn't present in Kaufman, which I think made it more strictly about the statutory language. And you don't go, and Kaufman, of course, says, well, foreseeability and knowledge don't really matter because, you don't pass that threshold under 105A. And we do pass that threshold, and then we can get on to, what created the duty in this case, the knowledge base, and what would and should have been warned against, and how that duty was not carried out. And another thing about this, in terms of statutory interpretation, Section 105A doesn't just sit there alone. There's also Section 105B. And under Section 105B, the statute says, in making the determination, i.e. of whether the product is defective or unreasonably dangerous, the state of scientific and technological knowledge available to the manufacturer or seller at the time the product was placed on the market, rather than at the time of injury, is applicable. Okay? Well, we didn't get there in Kaufman, but we get there here. Because we know from the record, it's established that Ford, for example, had ample technological knowledge related to the proper uses of this extender, also had ample technological knowledge as to why it was so dangerous if misused for a child, also had knowledge that consumers were proposing to use seatbelt extenders, Ford's in particular, to get around these pocketed seatbelt buckles in modern vehicles. And then on the other hand, we have Derell, who, as a booster seat manufacturer, one of the largest in America, makes booster seats under many different brand names, certainly has superior technological knowledge about what is a proper use and what is an unsafe use of a booster seat. And of course, they endorsed a misuse. So in terms of whether or not Kaufman, Kaufman is a little barren of facts, the decision itself. And I mean, I've searched the entire, back in time in Kaufman to see what was actually, being argued here and what were the facts. But the equipment in Kaufman, as far as I can tell, was sold and installed in like 1968. And so, and the asbestos-laden component parts that harmed Mr. Kaufman were incorporated years and decades later. And why I think it matters is because unlike Mrs. Kaufman, Woodruff can rely on the consumer expectation test and the prudent manufacturing test of Section 102.8. Those tests are not even mentioned in Kaufman because, again, it was just a strict statutory interpretation of Section 105A. It was an up, down, and it was down, and that was it. And there was no further need to go further. But here, the defendant's products were the end products that caused the harm, and not just the extender, as Justice Campbell's questions bear out, also the booster seat as a substantial contributing factor.
Mr. Collins, do you think that Kaufman was correct to analyze this as a question of duty? And I know there's a lot of overlap often among the elements of a product's liability claim, but I'm just wondering about your thoughts as to, what is the right way to think about this question? Is it more of a causation issue than a duty question?
I think Kaufman certainly was.
You think Kaufman really turned on causation?
Kaufman was a causation case because the plaintiff in Kaufman, as is the case with many plaintiffs, I think, in this second round of asbestos litigation, that sort of, that swept the country, DeVries and the O'Crane case in California, all these decisions where we get this bare metal defense, those really are fundamentally, in my view, a question of causation. But there's various different approaches that courts have taken. Some courts, like Kaufman, look at it in terms of stream of commerce. And I think that's what the Kaufman court really did when it said that, well, we're just going to find that there's no liability under that because this problem didn't exist at the time the product left the manufacturer's control. But I mentioned consumer expectations in the prudent manufacturing test because that's how we determine whether or not a product is defective or unreasonably dangerous at the time it left the manufacturer's control. Certainly with respect to the prudent manufacturing test, we're asking, what did the manufacturer know? And did the manufacturer act reasonably? So of course we have to engage in this sort of knowledge based inquiry in order to determine whether or not the product is defective or unreasonably dangerous.
Are we making that determination, though? Will we be engaging those tests to determine what's reasonable or not? We're just strictly, at this stage, determining whether the manufacturer could be liable in this factual situation.
In my view, what the court's job here is to determine whether or not Kaufman is dispositive of this case only. I mentioned these issues of reasonableness and the various tests under which we determine that because those arguments were overlooked by the court below, and they demonstrate, I think, why Kaufman doesn't fit this particular case.
So you would agree then that even if we decide that Kaufman does not apply here, that doesn't necessarily mean that the defendants had a duty to warn. That's still a determination that the court below, the trial court, will have to make based on those factors. It's not just because we rule that Kaufman doesn't apply here doesn't mean ipso facto there's a duty to warn.
I think I would concede that to extent other than the trial court has actually addressed this and has looked at every manufacturer in Tennessee. This is why, Justice Kimball, I'm not so sure that Kaufman was right to make this a duty question. And I don't want to be critical of the Kaufman court, but the problem with making it solely a question of duty is we're not actually doing business with, let me back up and try to think of a way to frame this. In Tennessee, going all the way back, so many cases. Let's think of, the Everidge case against Honda, the Young versus Reliance case. Case after case imposes the legal duty to reasonably warn and instruct to avoid danger. And that is encompassed also, going all the way back to the restatement Section 402 and the comments there too. We've always imposed upon manufacturers because if they don't adequately warn or instruct, then the product will be not reasonably safe. And so I just don't think that it's necessarily proper to look at these cases in terms of, well, is there a duty in this case versus some other case? Because the duty, if you're going to put a product on the market and you're in the business of selling or manufacturing that product, then you have a duty to reasonably warn of the risks of use and the dangers of misuse. That's there no matter. So whether or not the trial court would then look at this in terms of duty, I don't think I can see that winning here doesn't mean I win at trial, but I will say that the trial court has already passed upon the adequacy of, Ford's extender warning and says it's ambiguous, and Ford knew that this product was being misused, and it does not adequately warn in those respects. And then on the other side, similarly with Derell, the court has, by finding that plaintiff could proceed on a punitive damages claim, literally, that Derell recklessly endorsed that very misuse.
So for both, if we were to find Kaufman is just not dispositive here, what would be indicated would be to remand it to the trial court
Yes, Your Honor.
with that clarification?
Yes, Your Honor.
Okay.
If this court finds that, and the questions, the court consolidated these appeals.
But they're in different procedural postures.
Somewhat. Well, indeed, they are. They are indeed. But, because the court below agreed with Ford, they're sort of on the same footing now. But if you look at the question that this court was, had to take up in terms of Ford's Rule 9 appeal, it's just strictly Kaufman. And this is exactly what the question is that presented, and we asked this court to grant permission to appeal in the Derell matter as well. So it's the same issue, and so it needs to be remanded to the trial court for further proceedings and trial, which it has been set for trial before. And again, we ended up going to trial against Ford, albeit for only a few days. But
So Derell makes an argument that, even if we hold that Kaufman did not foreclose a duty to warn theory, that we should nevertheless, I guess, affirm on an alternative basis as to Derell, which is that there's kind of no, basically as a matter of law, the failure to warn claim fails because there's no evidence in the record that would support an inference that Mr. Woodruff either read the instructions or followed the instructions, even if he read them. Could you address that argument and why
yes,
that's
Your-
not correct in your view?
Yes, Your Honor.
And the building does have tornado facilities. If we-
Well, I find it relaxing, actually. Those issues, I think, were predetermined, specifically, indeed, by the Court of Appeals. So they're not really properly before the court. But never mind that. If you want to know my, actual response to it, it's a gross distortion of the record. In those issues, whether Woodruff read or should have read or this manual versus that manual or whatever, those are jury questions, fundamentally jury questions. And so
Well, but only if there's enough evidence in the record, to create a material issue of fact as to those questions. So what evidence would you point to
sure,
in the
okay.
record?
In terms of the reading Derell's manual, I think the fact that he went out and got an extender in the first place for this problem is sufficient for a jury to say, okay, well, he read that. Now, Derell's argument, though, is not so much that he didn't read it, it's that he didn't follow it right. But that is a jury question, because the manual says if your vehicle's belt is too short, contact a dealer about an extender. They say, well, he didn't contact a dealer as far as we know. He just went online. But what's a dealer? Everybody goes online. I mean, I don't think a jury is necessarily going to fault Ben Woodruff for not running out to, an official dealer, like an automotive dealer, versus going on eBay like any other reasonable person or juror would do. And that's really the substance of that argument. And they say...
Is there any evidence that he actually contacted a dealer? Is there any evidence that would even support an inference that he contacted a dealer, I guess if we understand dealer to mean the car dealer?
If we want to assume that means a car dealer, then no, not that I'm aware of. But really the question, as to whether or not, again, product warnings have been heeded, that is the province of the jury. Certainly there are cases when it's just, obvious. Like I would point to that Goins versus Clorox case that I began with, where you have these, the problem there was the plaintiffs didn't read it. I mean, both products warned, don't use this with either toilet bowl cleaner, that was from the liquid plumber folks, and the toilet bowl cleaner said, don't use it with drain opener. But the plaintiff didn't read it. But that's a proximate cause issue, and that's not before the court.
Why, in your view, why would we not have authority to affirm on that alternative basis? Sorry, I'm not in front of my microphone.
Well, because I don't think the trial court properly addressed it. It was never squarely presented to the trial court. And I also think that the record is incomplete, and not that the record just doesn't have evidence in it, but I think that in the briefing of this case in the court below, shortly before this case was litigated for years and years, but there's a whole host of declarations which we've provided by appendix in the court below and also in this court regarding the provenance of the Nissan manual, for example, because that's another one of these issues that were preempted by the Court of Appeals. And Ford relies on this one too, he should have just taken heed of the Nissan manual, but there was no Nissan manual recovered in the vehicle. So there, we don't know whether or not he read it. He didn't possess it. That's very unlike the extender warning, which is stitched onto the extender itself that was discovered with the vehicle, and also unlike the Derell manual with the offending endorsement, because it too was found with the vehicle. I just don't think it would be proper for this court to wade into those. I think that's the province of the trial court. Certainly, those issues may come before the trial court again, before this case reaches a jury, or there may be motions for directive. It's hard to know, but again, those are questions I think for the trial court and specifically the jury to address. And we do address these arguments in our pre-admitted or not. We do address those arguments in our brief. But I think that what I have found most striking about the Court of Appeals decision in this case, and I go back to this knowledge issue and foreseeability, and I think the Court of Appeals did a good job of reciting, the facts here, particularly when it came to Ford Motor Company's, prior knowledge that in any other universe would give rise to the duty if there's that certainly supports the need for more adequate warnings. But I struggle with this idea that Kaufman just eviscerates the need for any kind of inquiry around foreseeability, because how else do we know what would be an adequate warning or instruction to give? We have to look at that issue. And we have to look at it not just because 105B directs us to, but the decisional law also points in that direction. And I think a prime example of Section 105B is the Court of Appeals 2012 decision in Mills versus Ford Motor Company, in which Justice Kirby was on the panel. And that case also was against Ford Motor Company. And in Mills, Ford had failed to warn consumers that placing the shoulder belt behind a child's back could result in serious injury or death. And Mills didn't say Ford's knowledge of whether that was going on or not. That didn't matter. What Mills says is, on the failure to work claim, upon review of the record, we agree with Ms. Mills that the record contains material evidence that in its 1995 vehicles, Ford failed to warn of the, quote, hidden hazard of the foreseeable misuse of placing the shoulder strap behind children because it simply did not fit them. It is clear from the record that during the 1990s And into the early 2000s, the automobile industry, including Ford, increasingly recognized the need to provide better protection for children who had outgrown a toddler car seat, but were not large enough to properly wear a three-point seat belt. And more on the warning, the court goes on, the small sliver of the record demonstrates, or this small sliver of the record demonstrates the evolution of Ford's efforts and attention to the difficulty of safely restraining children. It provides material evidence to demonstrate that sometime between 1988 and 1993, Ford recognized that adult seat belts did not fit children and were inadequate to protect them, that placing the shoulder strap of the three-point seatbelt behind a child's back or under a child's arm was unsafe and could cause enhanced injury to children. By 1997, Ford clearly was warning consumers about the dangers of improper seatbelt use, which Ford now does, by the way, with respect to seatbelt extenders. But by 2001, it was advocating booster seats. In 1995, it was not, when that product left the manufacturer's control. But again, Ford's knowledge base back then, Ford had the knowledge, and it mattered to the Mills Court. And I submit it should matter to this court, too, that we have this record of Ford's actual knowledge. And that helps define what is an adequate warning or instruction in this particular case. And it's not just Mills where we're looking at knowledge, foreseeability in these issues. I mean, the Whitehead Court recognized that strict liability for products, I mean, it may be strict liability, but it's still fault-based. Lest we wouldn't have the ability to, lest the court wouldn't have recognized the doctrine of comparative fault in these cases, because it is fault-based. And the Court of Appeals just seems to gloss right over that, hanging on, cleaving to this, sentence in Kaufman, which one could argue is actually dicta, that manufacturers have no duty to warn about another manufacturer's product. It wasn't even really the holding in Kaufman. The holding was that this product was not made by the defendant, and so Section 105A, we just don't get into anything more. But from time to time, I've heard my friends suggest that, this case should sort of go the way of a component case, like Davis, for example. And I know in Kaufman, I can still, in my mind, look at it like a component case. I know it wasn't, because we have the the defendant integrator as a defendant. But, looking at this case under the lens of Davis, I don't think is altogether unhelpful, except for the fact that it doesn't actually apply, because we're not talking about components. But I don't think it advances the defendants as much as they think to do that exercise, because, in Davis, there were two ways that a component part manufacturer can still be held liable for a component. One is if the component was defective or unreasonably dangerous itself and led to the injury, right? And the Davis court, to quote it, says the plain language of 105A, a manufacturer of a component part clearly is liable for injuries caused by a component that was defective or unreasonably dangerous at the time it left the control of the manufacturer. Well, here, both products were defective or unreasonably dangerous at the time they left the control of these respective manufacturers. So Davis, under prong one, we cross the finish line. Go to the next one here. Absent a defective or unreasonably dangerous component, how else can a component part manufacturer be held liable under the Product Liability Act? Well, if they substantially participated in the integration, sort of this misfeasance that Satterfield talks about. And here, I mean, I know that we don't have an integrated product of boost, some kind of cobbled together product of extender and booster seat. But we do have a situation where the defendants created the risk.
Mr. Collins, I hate to interrupt you, but if you could try to make sure you're in front of the microphone, because
Yes, I apologize.
hearing you as well as people on the live stream
Thank you.
need the,
Thank you, Justice Bivens. I'll do that. But I think what the point I'm making is that if we look through this under that kind of lens, and I'm going to quote Davis here on the second prong, in this idea of an inverse implication from Section 108, that we have, we're looking at foreseeability in terms of whether or not the product's been altered or changed in some way that was foreseeable to the manufacturer. Therefore, a component manufacturer, there's justification to hold a component part manufacturer if they substantially contribute to the integration. But what the court says, I think, is telling in talking about 108. It says, under that any, quote, any alteration or change to the product would be foreseeable if we have that situation, that substantial contribution, and the use of the defective component part could not be deemed as abnormal as it was recommended, is what the court said, by the manufacturer. So if we were to parse that out, I know that was choppy, but I would word that as, looking at Derell in particular, if we look at that converse implication, Derell is liable under my hypothetical that this is some sort of like integrated product, which it's not, because any alteration or change to the booster seat would be foreseeable, and it's foreseeable because Derell recommended it. I look at Ford, and one of the
Well, is
cases.
that correct to say that Derell recommended it? I mean, Derell, I guess the instruction manual contemplated that one could contact the dealer about using a seatbelt extender, right? But the instruction manual didn't specifically advise to use it.
Well, I think that is a question for the jury. Is that an endorsement, a recommendation, or what? That is the jury question. We're still got to try this case. We were trucking right along for years, and nobody ever thought about the arguments that eventually ended up.
And then here comes Kaufman.
And here comes Kaufman.
Do you think that Kaufman was correctly decided? So set aside, whether it's duty or causation, but I mean, do you think the result was correct in that case?
Are you asking my personal opinion?
Well, I mean, in your role as an attorney for your client in this case.
Okay, as an attorney for my client in this case, I don't think it matters whether or not Kaufman was correctly decided, because Kaufman just doesn't fit. But if I were on the Supreme Court in 21, I would have joined Justice Lee, me personally, because I think that it was, I think that the court maybe didn't give enough credit to how we decide whether a product's unreasonably dangerous or not, okay? But I don't know the facts of Kaufman, and they weren't really available. And I go back to this idea that it was in 1968. Now, we know a seatbelt is not so complex that we can't use the consumer expectation test. Justice Bivens, you recognize that in the Tatham decision, written not even that long ago. But certainly asbestos, I think that one's got to, I don't know that an ordinary consumer can form a reasonable expectation about asbestos, especially not in 1968. But nor could a prudent manufacturer in 1968, could they? I mean, the first successful asbestos case was, I think, in 1965. I mean, a couple of years before, one obscure case down in Texas. So I don't know. I don't know. But thank you. This court should reverse the Court of Appeals in both appeals and remand the case for trial.
Thank you, Mr. Collins.
Good afternoon, Your Honors. May it please the court. Paul Hudson on behalf of the defendant appellee, Ford Motor Company. Your Honors, consistent with the court's instruction, we've conferred with counsel for Derell. If it pleases the court, Ford will go for 20 minutes and Derell will have the remainder. Thank you, Your Honors. Your Honors, plaintiff's only claim in this case is that Ford had a duty to warn against misusing a Ford Focus front seatbelt extender in the back seat of a Nissan Juke in combination with a Derell booster seat. That claim, as the Court of Appeals correctly recognized, is squarely foreclosed by this court's decision in Kaufman. The Kaufman court held that under the TPLA, a manufacturer's duty extends only to its own product at the time it leaves its control, and that necessarily means that there is no duty to warn of every potential danger that might materialize later if the product is combined with another manufacturer's product.
So, counsel, I am struggling with that aspect of this case. At bottom, this appears to me, anyway, to be a foreseeable misuse case. From the standpoint of the extenders, you should warn against using it with a booster seat. From the standpoint of the booster seat, you should warn against using it with extenders. There was no real element of foreseeable misuse in Kaufman. There was the addition of a product to the base product that was intended, and the added product had some inherently dangerous qualities to it. The framing of this case seems fundamentally different to me. I'd like to hear you address that.
Your Honor, I agree that the argument that the plaintiff is making here is primarily, however you dress it up, a foreseeable misuse argument. The whole argument they're making is that Ford knew or should have known in the run-up to this that people would misuse seatbelt extenders with booster seats. The part I disagree with there is that Kaufman directly addressed foreseeability. And in fact, the dissent had a lengthy discussion about foreseeability and the...
But there was not a misuse aspect, I don't believe, in Kaufman. It's been a while, but I don't recall there being, I mean, it was very much contemplated that these products would be added to.
Well, and I think that cuts the exact opposite direction, and it makes the case for dismissal here stronger than it was in Kaufman, because you're right, the combination of products there was not just foreseeable to the manufacturer, it was specifically intended and specified, and in fact, the product wouldn't even work without the combination of asbestos. And so that was the harder question that this court was wrestling with in Kaufman. The same exact question the U.S. Supreme Court was wrestling with in DeVries. And Kaufman rejected foreseeability. The United States Supreme Court, it was a 6-3 decision, but it was 9-0 rejecting foreseeability as a test. And so I guess the way I would frame it is if a manufacturer has no duty to warn when it specifically intends a product combination, then certainly a manufacturer should have no duty to warn when it does not intend that combination. And that's the fact pattern we have here. So I submit that this case for dismissal is stronger.
Okay, so that goes perhaps to whether Kaufman, some of what is said in Kaufman should be extended to a different circumstance. But really the question presented to us here is, did Kaufman decide this? And I am struggling with that.
Understood, Your Honor, and I guess I'll answer it two ways. Number one, I think to honor the full scope of the Kaufman holding, we have to recognize that this was not, number one, limited to asbestos cases. The holdings that were announced, there were 3 sentences in the decision that say expressly, we hold. They are all general holdings about all claims brought under the Tennessee Product Liability Act. For example, we hold that under the TPLA, manufacturers have no duty to warn with respect to products manufactured and sold by others. Repeats that holding. No carve-outs for certain types of cases. It's a general bright line rule that applies to every claim brought under the TPLA. Number two, and we heard this from Brother Counsel today, distinguishing Kaufman factually by calling the Ford extender or the booster seat the end product at issue. And the claim is that the extender failed or came unlatched in the accident. To be clear, we dispute that in fact happened, but that's a factual question that's beyond this. But the key fact here is that everybody agrees, including plaintiff's own experts, that there was nothing wrong with this seatbelt extender. It was only when another manufacturer's product was added that the alleged harmful condition.
That's the foreseeable misuse aspect of it, and I don't see that in Kaufman.
Well, I guess to line up the facts specifically with Kaufman, there was nothing wrong with the equipment manufacturer's pipes and valves and gaskets. It was only when you added asbestos insulation to those products that it became dangerous. Same thing here.
Is there a difference between added, you keep using the word added, in Kaufman it was two products added together, maybe one end product. Here, do we have a similar situation where you have two products becoming one, or just two products being used simultaneously, and does that make a distinction?
I think whether you call it a combined product, an integrated product, it doesn't make a distinction. The distinction doesn't make a difference under Kaufman. The point is, wind it back, what is the manufacturer's duty to warn? It's about its own products, not about, in the words of Kaufman, your own product plus some later included product.
But let's go to the distinction that I think Mr. Collins drew, or one of the distinctions that he drew, was that in Kaufman, it wasn't the metal equipment that actually caused the injury, right? It was it was the added product that caused the injury, whereas here, you could at least arguably say that it's both products that together caused the injury. I mean, we have, in other tort cases, right, we have a joint tortfeasor doctrine that, says if you've got multiple causes of an injury, you can hold each of the individual causes liable. I mean, why isn't that really more the situation that we're dealing with here, where, both, it may be that each product alone wouldn't have caused the injury, but when used in combination with one another, they both are contributing to the cause of the harm.
Yeah, I guess just to analyze the facts of Kaufman a little bit, I do think it's the case that it is some combination of those products that led to the injury, right? The only reason Mr. Kaufman in that case was exposed to the asbestos fibers was because they were integrated into these pipes and valves and gaskets. It wasn't just sort of encountering asbestos on its own. It was having to sort of scrape the asbestos off the.
But it was the asbestos that was the injury-causing product.
Well, I guess probably.
In a way that isn't true here.
Arguably, it was probably. The plaintiff was certainly alleging both, right? They were alleging that the equipment manufacturers had some responsibility for at least the delivery mechanism of the asbestos. And I think to go to the Court of Appeals decision in Kaufman, this whole idea of, labeling one product the end product at issue, that was the basis of the Court of Appeals decision in the Kaufman case. And they said on page 17 of the decision, the asbestos-containing parts are the components, and the defendant's valves, pumps, and steam traps are the final integrated products. So I don't think it works to just sort of say, there was one product, asbestos, that's what caused the injury, and therefore this case is distinguishable. I think to honor the holding of Kaufman, the idea is, what is the manufacturer's duty to warn? It's a duty to warn about its own products, not the combination of products. And I understand. I will readily concede that creates dangerous. It creates difficult hypotheticals, right? Because there are going to be easily foreseeable product combinations where you might just ask, why wouldn't a manufacturer warn in this situation? A very good one is the liquid plumber and bleach example. But that's sort of the nature of a bright line rule, and what courts, the long lesson of product liability law is that a
But that's
foreseeability.
that's the nature of foreseeable misuse cases.
That's right, and
The Meals Ford Motor Company case was that type of case where it was a misuse of the product. Here, the misuse is to use these two products together.
That's right.
That just seems very different from the issue presented in Kaufman.
And it's the foreseeability issue it's an issue that courts have wrestled with. I think the Plaque amicus brief does a good job laying out that the Kaufman rule is well within the mainstream nationwide in these cases. There are all these very good quotes in these decisions that on clear judicial days, courts can foresee forever. And I think that's the wisdom of this no foreseeability rule is, it protects manufacturers from having to include phone book size warning labels on every single one of its products, right? And the problem here is it's always easy in retrospect to say, well, somebody should have foreseen this happening. But for example, you could imagine
But here
hypotheticals the other way. Does Ford have a duty to include on this 2-inch wide seatbelt label, don't use it on an airplane, don't use it on a roller coaster, don't
But
use it
here
on a...
we are being asked to take that away from the jury.
Well, and to answer a question earlier about whether this is a question of duty, I absolutely do think it is. This is a threshold question. The only claim is that Ford should have repeated the exact same warning that was provided in the Nissan manual that said never use seatbelt extenders to install child restraints. The only claim is that Ford should have repeated those exact same words on this 2-inch wide seatbelt extender. So I do think that's the threshold legal question, and I submit that is answered by Kaufman, or at least the underlying principles of Kaufman, which are, we go to the text of the TPLA. It always focuses on a manufacturer's own product, and it doesn't extend to these other future situations, making manufacturers anticipate them.
What text in the TPLA are we construing in this case?
Well, I think the Kaufman court ran through it, and what the court said there is every single time there's a reference to a duty on behalf of a manufacturer, it always refers to the manufacturer's own product.
What I'm trying to focus on is if we are in these two cases construing the same language in the TPLA that Kaufman did. So I'd like you to isolate that for me.
Sure, Your Honor. It is 102.2. Defective condition means it renders it unsafe for normal or anticipatable handling and consumption. The Kaufman court interpreted that to mean, in this case, the if is the equipment defendant's original product, not the product plus some later included products. So I think that's the same language. There was a lengthy discussion in the dissent about another provision of the statute, and that's section 108 that says a manufacturer is not liable for, quote, subsequent unforeseeable alteration, change, improper maintenance, or abnormal use. And the dissent's point there was, all right, if it says you're not liable for unseeable misuse or abnormal use, then the implication of that is manufacturers are liable for foreseeable. The Kaufman court majority considered that and rejected it and said, either way, we're still talking about the manufacturer's own product. So those are the key provisions of the TPLA that were interpreted in Kaufman and apply here as well.
Counsel, how would your framework or your bright line rule apply in one of the hypotheticals that Mr. Collins presented, which was the use of a hairdryer, near water, where the hairdryer is being kind of dropped into the water? I mean, there you have it being used, I guess, in a misused, or it's not really an abnormal use necessarily. I mean, that's foreseeable, but it's not a different product. I take it from your answer a moment ago that in the case of liquid plumber and Clorox, you would, if you apply your theory of the case to that or your rule to that, you would say there's no duty to warn in that situation, even if it's a highly foreseeable use of the product.
That is correct, to answer your question.
Sorry, that was a multiple pronged question.
No, and I don't want to fight the hypothetical, so I won't. I think the answer from Kaufman is no, there is no duty to warn. The hairdryer in the bathtub one has always been a little weird to me because I'm not sure if water is a separate product. So set that one aside. The liquid.
Let's say it's a bottle of water. You got a bottle of water right there.
So,
It's not
I mean, then the question is,
you
does a
spill the bottle
hairdryer,
of water, on the hair dryer as you're using it.
so the hairdryer manufacturer would not have a duty to warn on its label saying, don't drop this in a bottle of water, I guess is the answer.
Or use caution around water, I just find it, it's a very extreme rule that you're asking us to adopt that would preclude liability in any situation where the dangerousness of the product arises from a foreseeable use in combination with another product.
Let me try it this way with the liquid plumber and bleach hypothetical. The reason that there are warnings in those cases, and that the Goins versus Clorox case that they reference, there actually was a warning in that case. That wasn't the question. The reason there are warnings is because in certain product areas, we have legislation, we have regulation, we have agencies that are regulating these products. And so in certain areas like chemicals, for example, where there's not sort of an intuitive sense from a consumer on how to use this product, then there are express requirements that manufacturers warn in these areas. Think of pharmaceuticals as well. The reason I think that that's relevant here is that the Kaufman court repeatedly said, listen, we are not here to decide what the optimal public policy result is. That's for the legislature. And here, for example, this is a extensively federally regulated area with NHTSA regulations for both vehicles and car seats. And so I guess the point there is we can have these bright line, easy to administer rules without having to sacrifice consumer safety. Another doctrine that this court has recognized is the component parts doctrine that Brother Counsel mentioned. In cases where you're truly where there's an intended integration.
Again, though, Kaufman was just interpreting specific language in the TPLA. We weren't going into a lot of doctrines, policy decisions, that sort of thing. And part of what Kaufman focused on, for example, was the definition of defective condition in the TPLA was a condition of a product that renders it unsafe for normal handling or anticipatable handling and consumption. And Kaufman really emphasized the fact that it was singular. So applying that definition here, the use of the extender is normally safe. But combined with a booster, it becomes unsafe. The converse with the booster seat, normally very safe. But combined with an extender belt, renders it unsafe. And so Kaufman focused very much on that's a singular in this statutory definition. But that's a difference in this case because what they're alleging is that this use of the product, either product, either the extender belt or the booster seat, renders it singular, unsafe.
And I think the key here is that they I think will agree with me that the forward seatbelt extender was safe for its normal and anticipatable uses, right? It's designed for larger adults to extend the seatbelt in the front seat of a Ford vehicle. It was perfectly safe for that purpose.
And we have to adopt a rule that you cannot be liable for foreseeable misuse under that theory you just described, though? Because you're saying it's safe under normal uses, but if this is a foreseeable misuse, is there simply no liability because it's a misuse?
And the definition in the TPLA specifically talks about anticipatable handling.
And I think what Kaufman answered there is if we're talking about foreseeable misuses of a product in combination with another manufacturer's product, that's the only way that this dangerous condition is created, then there is no duty to warn by the manufacturer. And that's the foreseeability question. I'll just read one quote from the DeVries case where they 9-0 rejected foreseeability as the question. They said many products can foreseeably be used in numerous ways with numerous other products and parts, requiring a product manufacturer to imagine and warn about all those possible uses, with massive liability looming for failure to correctly predict how its product might be used with another product or part, would impose a difficult and costly burden on manufacturers while simultaneously overwarning users. So again, there are policy considerations on both sides. There's certainly a balance here between what we are requiring manufacturers to warn against. Here, we did have warnings on the seatbelt extender itself. It said,
Mr. Hudson, you need to wrap up. You'll answer.
it said, thank you, Your Honor, do not use extender unless physically required in order to wear the seatbelt. That wasn't the case here. Use only extender only in the position it was provided for. It was not. It was misused here. So, Your Honors, we asked the court to affirm the Court of Appeals judgment below. Thank you, Your Honors.
Good afternoon, Your Honors. Jonathan Judge on behalf of Derell Juvenile Group, and may it please the court. Respectfully, it is Derell's position that there is, in fact, a duty question being addressed by Kaufman, and it gets to the question of the fundamental fact that there is no duty to warn about something you have no duty to warn about. I do believe that the language of the TPLA is actually being construed in many of these cases, even if it is not being directly mentioned. And I think the TPLA actually creates a sort of division between two very different types of claims. One type of claim is the claim that was a problem for seatbelt extender pros in this case, where you are selling product A, and the basis on which you sell product A is that you pick out product B and you say, my product is designed to work with product B, which is what they did. And so they were subject to suit for these affirmative representations that they made about product B, and therefore under either a misrepresentation theory or a warranty theory, the TPLA allowed them to be held liable, and they reached a settlement in the court below. But it is quite different when we are talking about something you didn't do, something you didn't purport to go out and research, something you didn't purport to be an expert on, and even in this case where Derell suggested you go talk to your vehicle dealer because they're the person who talks about it. And so respectfully, I do believe there is a big difference between taking an affirmative act about another product versus simply not either mentioning the other product or, on the converse, simply offering very general advice about the fact that this other product exists. The Tennessee Product Liability Act, as the Court of Appeals correctly held, requires Derell to warn about the dangers of its own product, but not to warn about the dangers of other manufacturers' products or possibly unsafe combinations.
How is that not a warning about the use of your own product?
It is. It is a warning about the use of your own product, but it gets into the question of whether some other product might have a defect that creates a condition that makes your product dangerous, which is a limitless world of foreseeability that, in our view, the TPLA and Kaufman has decided is too much. I think what's also notable is that the Court of Appeals correctly held in the alternative that regardless of what the TPLA does or does not allow, and regardless of what claims plaintiffs say they would like to advance at trial, that the record simply does not support the claims that they are asserting against Derell in terms of what Derell supposedly said, in terms of its manual ever being read, or in terms of its manual ever being followed. I certainly understand, to get back to the example of what ensnared seatbelt extender pros, which under the TPLA was subject to this court's jurisdiction and held accountable, I certainly understand if a company were to say, the great news for you is I want you to go out and use this second product because it makes my product safer, or it's the best, most convenient way to use my product. But we didn't do that here. The Court of Appeals found that we did not do that, and that was not challenged before this court. It has not been challenged anywhere in the appellant's brief. So those factual findings are what they are, and they're well supported by the record. So this is why, even if the court disagrees that Kaufman governs this case, the court's summary judgment ruling can be affirmed on one of two alternative grounds as to Derell. Grounds that the Court of Appeals understandably found to be pretermitted, but that are well supported by the record. First, there is
Why
no...
would we take those pre-terminated issues up?
It is certainly up to this court's discretion. The court has the ability to do that. What I would say is that this case has been pending for over 10 years. It is a de novo analysis of what the record does or does not have. And I think sending it back down to the trial court would be inefficient, particularly if it is a futile event, that it goes down and just eventually dismisses it anyway. We completely understand that it is a matter of the court's discretion, but since Derell has these additional issues, and counsel suggested that the court below did not pass upon them, I don't believe that's true. If one reviews the transcript from the court hearing below, the plaintiffs were trying to argue, unsuccessfully, that they had offered a misrepresentation claim. The trial court found that they had not done that. The Court of Appeals found they had not done that. That finding was not appealed. It is law of the case. But the trial court specifically got into this issue of, there is no evidence that he read this manual. There is no evidence that anyone thought he read the manual. So I do not think that it is something that is cold or that is benefited from sending it back down to the trial court, even though I understand that normally that might be the inclination.
We could, I guess, send it back to the Court of Appeals.
Sure. That could be done as well.
But they would be in no better position, really, to address the issue than we are. I mean, we could review it just based on the record that's before us.
Correct. It is a de novo call, and it would come back up here, presumably, with no presumption of correctness. Again, it is completely up to Your Honor's discretion. We all know that. But if you feel it is sufficiently clear on the record, if the case is going to continue, we do not think it should continue on and on and on with one party that is simply not going to be there if and when the case is tried again.
What's your response to Mr. Collins's argument about, I guess, why there is sufficient evidence in the record to support an inference that the instructions were followed? I believe he argued, that it sort of depends on how you read dealer and, who he might have contacted. But do you have any response to that, or?
I do. That's the first time I've heard this suggestion anywhere in this case, and in terms of the dealer being kind of a construct, it says vehicle dealer. And with respect, again, it goes to two different things. It's whether you even read it, of which there's no evidence he did, and then there's, did you take their advice and go talk to your vehicle dealer? I mean, if eBay is not a vehicle dealer, it certainly wasn't for this vehicle or for this anything else, and I don't think that's a complicated concept. And again, we are at the summary judgment phase where either there is evidence that you did that or you didn't. So, quite honestly, that all the evidence in the record is that he independently was searching around online and Googling and trying to see what do you do when you're unhappy with your seatbelt booster seat daycare drop-off configuration, and, apparently happened upon seatbelt extender pros and all of these other things. So I would say there is literally no evidence that anything Derell said was followed, comprehended, taken into account. And on that note, counsel seems to be kind of urging, with the misrepresentation theory no longer being in play, now we're hearing about an endorsement. There is no endorsement cause of action. There is no offering the wrong kind of vibe in your manual cause of action. It is very clear, in my view, under the TPLA, that either you specifically told them to do something, which, if it affected another product, is your problem, or you did not. And it is not simply a matter of you did not sufficiently, to my belief, condemn this other product, which is something that I think is particularly important in the Davis case.
Where do you see that distinction between misrepresentation and failure to warn in the text of the TPLA? What are you relying on?
The definition, I apologize, Your Honor. For me, at least, it was in the definition of all the causes of action that were covered by the definition of a product liability action. And it just struck me how perhaps it was a comprehensive list because the legislature was trying to make a point. But to me, they were listing out all of these options that you had for people who actually went out and made an affirmative statement that was problematic, innocent, negligent, intentional. And so they have, misrepresentation, 3 types. They have implied warranty, express warranty. And so in my view, that is the TPLA saying we recognize that there are these times when you have taken this affirmative action, and you will be held accountable for that if you meet the traditional definition of these things.
So the Kaufman issue related to your product is not, the argument about affirmative misrepresentation is not crucial to it. I think what they're arguing is that Derell had an affirmative duty to warn against the foreseeable misuse of your client's product with extender belts.
I agree.
So speak to me about why Kaufman is dispositive on that theory, because I'm not seeing that.
To be honest, Your Honor, I've seen it as more of a TPLA issue than a Kaufman issue, although they're supposed to be very similar.
Kaufman interpreted
Correct.
the TPLA.
And so I've always sort of viewed them together. And to me, this point I'm making about reaching
Then
out affirmative.
what language in the TPLA, to that point, what language in the TPLA do you see us as construing as to your client's case?
It would go back to the its product. It's the combination
It
of
would
the
go
its
back to
product,
what?
the defect as to its product, as to its individual
Defective
product, which we've
condition,
discussed.
the definition of defective condition.
Correct, Your Honor. But it is informed by the gloss of the Davis case, which I think offers some really valuable, unfortunately, the Davis case kind of just talked about the component parts doctrine as sort of a kind of a law professor restatement sort of thing. Good decision, good doctrine, but it really informs respectfully what this duty to warn means and ought not to mean. And in my view, that decision of this court is incredibly informative because it had to deal with this very interesting question, construing the TPLA, of, well, what do we do when your product is, in that case, integrated with, but in any event, the most possibly foreseeable combination of product you can imagine? What are you allowed to say without becoming beholden to whatever is the end result of what your product ends up on? And they said, if you're just given general advice about your product and how it might be used, that's fine. And what did you then say? You said, okay, but if you affirmatively go out and pick a particular product, that's a problem. And they also said if you actually were sitting there designing this, final product, whatever it is, like you literally sat there and contributed to the design, you did all these other things, then you would be responsible for that. And so I think the view there is, again, I really think this is a situation where the foreseeability issue cuts the other way. If a component part manufacturer who is making widgets for a particular machine, who knows where this product is going, is being told, don't worry, as long as you are not down there, designing and putting it in there in the factory and how it's all going to work together, you do not have to be responsible for that. That, in my view, has to apply to 2 products that have warnings up and down that should have prevented them from ever being put together, and by the unilateral acts of a third party who is sort of cramming them together and overriding multiple safety features, that party should not be held accountable. Certainly no duty to warn for that.
So what you seem to be asking us to do, I think that the kind of affirmative misrepresentation or component part sort of situations are situations where there was clear foreseeability, right? That the products would be used together. That was
Sure.
actually contemplated.
Sure.
But what you seem to be asking us to do is to completely foreclose any consideration of foreseeability outside of that context, even though there very well could be situations, right, where even though you're not in one of those worlds where you have, an affirmative misrepresentation about how they could be safely used together, or where they were designed so as to be used together, you could have a situation where there is still evidence, strong evidence, that this was an anticipated use of the product, and you're asking us to just cut off all consideration of foreseeability. And that's what I am struggling to find a basis for doing that within the TPLA itself. I mean, if you look at the definition of defective condition, which I heard you say a moment ago that that's kind of where you're getting this, it just means a condition of a product that renders it unsafe for normal or anticipatable handling and consumption. And so if there is evidence that that the manufacturer knew, it was foreseeable to the manufacturer that the product would be used in conjunction with another product and that would be an unsafe use absent, some warning, that would seem to fall within the definition of defective condition. So where in the TPLA are you, I guess, finding a basis for just cutting off that inquiry altogether in these cases?
Aside from what's previously been discussed, I'm looking more to the case law and to the policy statements in which the court in Davis specifically said, and all of the courts we've been citing to, which unanimously say, once we get another product involved, we are crossing a very particular line. And asking one manufacturer to anticipate, and in many cases just guess, what should have been done with some other product that they're not an expert in, that they did not themselves design.
But
that
doesn't the language that your client's product had on the bottom of it indicate not only that it was foreseeable, but that it was actually foreseen by your client?
It was
even if the father never saw it, never read it, doesn't it indicate that your client actually anticipated it might be used with extender belts?
Sure, in the sense that they recognized that the status of seatbelts at the time were a bit of a Wild West, and that's why they offered their general advice, as the Davis court would say, to go and talk to your vehicle dealer about it. Yes, I agree.
Okay.
So
the issue, your argument as to the evidence that the instruction manual was never read and even if it was read, the instructions weren't followed, that really goes to causation. What element of the claim?
I agree.
Causation.
I agree.
Okay.
Because it's really about, the fact is at that point the product is out. So any duty you had or did not have has either at that point been satisfied or not satisfied. And so it goes to it goes down, into the actual use, and then we start seeing, okay, is there a causal connection or not? And what I will say for these situations is that I understand that, oftentimes this is the showing of proof can be sort of an interesting exercise. And so courts are generally somewhat forgiving about saying you don't have to have ironclad, proof to go to a trial. But it has consistently been my experience, and I think with good reason, because some people just don't read these things, and nothing that you would have said would have affected their conduct. They say, I need something. I need some evidence that, that I found it, that he says he read it, or that his wife saw him reading it, or that we saw it among his manuals and materials, or something. And the reality is, it just isn't here. I frankly don't understand how telling someone to go talk to their vehicle dealer could be bad advice, period. I mean, if you consider the fact that literally if they would have given them a Nissan Juke seatbelt extender, it would not have worked. It was impossible, following Derell's advice, to end up in this predicament. But we don't have to go that deep into the record. We can simply say that, as a matter of law, to get to the jury, we have to have some basis, other than simply presuming that he must have read it because he did something that matches up with like 3 of the words out of your multi-page manual. And right now, that's all that's really been urged. And I think the record suggests that, a booster seat, we're talking, most of us have used them. You take it out of the box, you put it together, you put it in the vehicle. You can do that. It's not exactly a complicated exercise. There is simply no evidence that he ever read anything. If there was an issue about at the point of sale, Derell would have said, hey, this is going to complete your experience. More interesting question. But that's just not this case. And having to go back down with this very factually distinct causal connection not being there, I think if Kaufman is found not to apply to this general fact scenario, that demonstrates why Derell should not be a part of the proceedings any longer, regardless. That's all I have, unless there are any other questions from the court.
All right, thank you, counsel.
Thank you, Your Honors.
Mr. Collins.
May it please the court, I want to address, I want to go where Mr. Judge left off on these pre-permitted issues, because Justice Kirby, I don't know that I was really as complete in my response to you as I could have been, and that's one of the good things about having co-counsel here. This idea, I'm going to address this in two ways. First is the evidence that he read it. Okay, there's more than what I've mentioned before, but also why it would be so manifestly unjust for this court to take up that causation issue, not only because it's a jury question, but because of the very peculiar way, the procedural history of this case. To begin with, whether or not Mr. Woodruff, Ben Woodruff, read the Derell manual, he most certainly did. Now, there are different types of booster seats. There's the kind that just, that I sat on as a child that just is it's like a block. And granted, if one of those, you probably don't need to read an instruction manual. But then there's the kind that my son just graduated from with a high back and a notch for the shoulder belt to come through. Okay, it's a high back booster seat. That's what Ethan Woodruff's booster seat is a high back booster seat. And it comes in a box, the base and the back, and padding, and maybe a couple other parts that you actually do have to assemble. You have to read the instruction manual in order to assemble it, unless you've just done a lot of them. So that's evidence that Mr. Woodruff read the booster seat manual, because he had to have put together the thing. They don't come already assembled. And they're not intuitive either, especially when it comes to putting on the padding. Or, frankly, putting on the back, because you've got to kind of configure it. You've got to follow the instructions. The instruction manual says, once you're done assembling it, take this little packet and put it under the booster seat in a special little pocket that Derell has for stowing the instruction manual. Well, that's where evidence shows the booster seat manual in question was stowed. So that's more evidence that he read it. So there is far more than just he got an extender, but that too is evidence. There's also testimonial evidence from Beth Woodruff that he had a habit of reading everything. Ben Woodruff was a graphic designer, one of the more meticulous types. And she testified that he did have a habit of reading manuals. Now, this issue of go to a dealer, whether it's a suggestion, endorsement, recommendation, whatever. Justice Kirby, your questions definitely hit the issue on the head. I mean, this is not just a foreseeable use, it's a foreseen use by Derell. Now, procedurally, on all these questions, and they've always been couched in terms of causation. There's he didn't read the manual, and then they also confusingly argue abnormal use, which we know would abnormal use and using the seatbelt extender, ironically, but both of those are jury questions. But procedurally, this case, Derell was moved for summary judgment on the no duty to warn issue first. And yes, they did also argue, there's no evidence that Mr. Woodruff read their manual. And the court said originally, there's no duty to warn about another manufactured product, just kind of like parroting Kaufman. And then goes on in that same order to say, and it was adequate, what they said, in their manual, that Ben Woodruff, let me see.
that up to the microphone.
Yes, I'm sorry. I will remember. Let's see. He says it's sufficient under the circumstances to warrant a purchaser not to use a seatbelt extender. It's a very confusing order. But we filed a motion to reconsider. And in that motion to reconsider, we said, no. You're wrong about this duty question. These folks endorsed it. And furthermore, we know Ben Woodruff read the manual because of the reasons that I gave. And the court said, you're right, and reinstated Derell into the case. Then we come down the pike, and Derell files a motion for interlocutory review. That sits at the trial court for, I think, 13 or 14 months. And it wasn't set for any kind of hearing until we're there on motions in limine, preparing for trial on February 15th, in fact, of 2023. And Derell re-raises this Kaufman issue, the Kaufman issue only. And this time the court inexplicably rules, no, you're out again, Derell. So you're dismissed. But it was in the context of a motion. There wasn't a dispositive motion pending. So procedurally, it would be manifestly unjust for this court to take on that kind of issue when there's that kind of procedural irregularities around this. On this idea around the Nissan manual, because the Nissan manual does warn against using seatbelt extenders. Again, there's no evidence that manual was not recovered. But in the heat of the moment at this February 15th hearing, of course, I'll say, Kaufman doesn't apply, but more importantly, call it misrepresentation, whatever, We have an endorsement or suggestion here, and the court got the manuals confused at this point. He confused the Nissan manual, which there's actually no evidence that Ben Woodruff ever read, with the Derell manual, which the court had already determined he clearly read. And he says, for that reason, you don't have a misrepresentation. So it's just there's too much there, I think, for the court to take up these pre-determined issues. And they're the types of issues that go to a jury. To begin with, a couple other points. Justice Kirby, your questions around was Kaufman just a statutory interpretation case? I think I understand that question better now after listening to the question again, and it kind of dovetails with what I was saying about why Kaufman doesn't talk about ordinary consumer expectation or prudent manufacturing. It's not so clear to me, at least, in Kaufman, that we're really just dealing with 102.1, I think, definition of a defective product versus an unreasonably dangerous product. And that in the event, if that's what Kaufman was doing, I think I understand the opinion better, that you cannot argue that this product or this integrated product that you didn't really make anyway is unreasonably dangerous. You don't have the proof for it. So it'd have to be a defective product, and there you've got this singular it. So maybe that's a way to understand Kaufman better. And unless there are any more questions, that's all Woodruff has. We ask that the court reverse and remand. Thank you.
Thank you, Mr. Collins. Thank you, counsel, very much for very good arguments. We appreciate it. Court will stand in recess. Thank you.